Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Ladies and gentlemen, first thing I want to tell you is this, I've gone over all the instructions this morning. One thing I wanted to let you know is this, before I read you the instructions, is that you may see that the numbers are mixed up. There may be some missing numbers. There might be a letter in there. All of these are the instructions of the court. Pay no attention to the number, the fact that there are missing numbers. I've gone through these. All the instructions are here. Same with the exhibits. When you go back into the jury room, I've gone through those. It took me about an hour last night, but I made sure every exhibit is in the box, so you'll have all the exhibits as well. You may notice that there are missing numbers there as well, but all the exhibits you will have access to all the exhibits. You will also have these instructions. So I'm going to read them to you. I'm required to read them to you, but you do not need to memorize them or take notes or anything like that, because you'll have these instructions to take back and review with, as far as what the law is. And again, this is the law of the Commonwealth of Virginia, and these are the instructions that are applicable to this case. So with that, I will begin. The defendant is presumed innocent. You should not assume the defendant is guilty because he's been indicted and is on trial. This presumption of innocence remains with the defendant throughout the trial and is enough to require you to find the defendant not guilty unless and until the Commonwealth proves each and every element of the offense beyond a reasonable doubt. This does not require proof beyond all possible doubt, nor is the Commonwealth required to disprove every conceivable circumstance of innocence. However, suspicion or probability of guilt is not enough for a conviction. There is no burden on the defendant to produce any evidence. A reasonable doubt is a doubt based upon your sound judgment after a full and impartial consideration of all the evidence in this case. The Commonwealth bears the burden of proving beyond a reasonable doubt the identity of the defendant as the person who committed the crime charged. If the Commonwealth has not met this burden, you shall find the defendant not guilty. The defendant does not have to testify, and exercise of that right cannot be considered by you. The fact that the defendant has been indicted by a grand jury is not evidence against him, and you should not consider it. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be disregarded. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. 1, that the defendant did kill Doris Puleio, and 2, that the killing was malicious, and 3, that the killing was willful, deliberate, premeditated, and 4, that the killing occurred in the commission of an attempted robbery. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the first 3 elements of the crime as charged, but you do not find beyond a reasonable doubt that the killing occurred in the commission of an attempted robbery, then you shall find the defendant guilty of first-degree murder. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any one or more of the first three elements of the crime, then you shall find the defendant not guilty. You are instructed that a killing is in the commission of an attempted robbery if it is so related in time, place, and causal connection as to make it a part of the same criminal undertaking or enterprise. This can occur before, during, or after the attempted robbery. Malice is that state of mind which results in the intentional doing of a wrongful act to another without legal excuse or justification at a time when the mind of the actor is under the control of reason. Malice may result from any unlawful or unjustifiable motive, including anger, hatred, or revenge. You may, but are not required to infer malice from any deliberate, willful, and cruel act against another, however sudden. You may, but are not required to infer malice from the deliberate use of a deadly weapon, unless from all the evidence you have a reasonable doubt as to whether malice existed. A deadly weapon is any object or instrument not a part of the human body that is likely to cause death or great bodily injury because of the manner and under the circumstances in which it was used. To prove the charge of murder, the Commonwealth does not have to prove a motive for the killing. The presence or absence of a motive may be considered in arriving at your verdict. Willful, deliberate, and premeditated means a specific intent to kill, adopted at some time before the killing, but which need not exist for any particular length of time. The defendant is charged with the crime of aggravated malicious wounding. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. 1, that the defendant shot Ann Goetz. And 2, that such shooting was with the intent to kill, or permanently maim, disfigure, or disable Ann Goetz. And 3, that the act was done with malice. And 4, that as a result of the act, Ann Goetz was severely injured and was caused to suffer permanent and significant physical impairment. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any one or more of the elements of the crime, then you shall find the defendant not guilty of aggravated malicious wounding. Visible scars, including those not visible during ordinary daily activities, are permanent and significant impairments. The defendant is charged with the crime of attempted robbery committed by using or displaying a firearm in a threatening manner. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. 1, that the defendant intended to commit robbery by using or displaying a firearm in a threatening manner. And 2, that the defendant did a direct act towards the commission of the robbery, which amounted to the beginning of the actual commission of the robbery. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty of attempted robbery committed by using or displaying a firearm in a threatening manner. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either of the elements of the crime, then you shall find the defendant not guilty. The intent required to prove an attempted crime is the specific intent in the person's mind to commit a particular crime for which the attempt is charged. In determining whether the intent has been proved, you may consider the conduct of the person involved and all the circumstances revealed by the evidence. The direct act required to prove in an attempted crime is an act which shows a present intention to commit the crime. The act need not be the last act prior to the actual commission of the crime, but it must be more than mere preparation. It is not a defense to attempted murder that the defendant voluntarily withdrew before actually committing the robbery. The defendant is charged with the crime of shooting at an occupied building. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. 1, that the defendant shot at a building occupied by one or more persons. And 2, that the life or lives of such persons may have been put in peril. And 3, that the act was done with malice. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find the defendant guilty of maliciously shooting at an occupied building. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. The defendant is charged with the crime of using a firearm while committing or attempting to commit aggravated malicious wounding of Ann Goetz. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. 1, that the defendant used a firearm, and 2, that the use occurred while the defendant was committing or attempting to commit aggravated malicious wounding. If you you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find the defendant not guilty. The defendant is charged with the crime of using a firearm while committing or attempting to commit the murder of Doris Puleio. The Commonwealth has proved beyond a reasonable doubt each of the following elements of that crime. 1, that the defendant used a firearm, and 2, that the use occurred while the defendant was committing or attempting to commit murder of Doris Puleio. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find the defendant not guilty. A firearm is any instrument that is capable of expelling a projectile by force or gunpowder. A firearm is also an object that is not capable of expelling a projectile by force or gunpowder, but gives the appearance of being able to do so. The existence of a firearm may be proved by circumstantial evidence, direct evidence, or both. Statements presented to you as having been made by the defendant are submitted for your consideration along with all the other evidence. The weight, value, credibility, and reliability of those statements are questions for your determination. If you believe from the evidence that a witness has previously made a statement inconsistent with his testimony at this trial, the only purpose for which that statement may be considered by you is for bearing on the witness's credibility. It is not evidence that what the witness previously said is true. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable conclusions from the evidence. You may convict the defendant on circumstantial evidence alone, or on circumstantial evidence combined with other evidence, if you believe from all the evidence that the defendant is guilty beyond a reasonable doubt. When the Commonwealth relies upon circumstantial evidence, the circumstances proved must be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved create a suspicion of guilt, however strong, or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You may consider the appearance and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth and for having observed the things about which they testified, their interest in the outcome of the case, their bias, and if any have been shown their prior inconsistent statements, or whether they have knowingly testified untruthfully as to any material fact in the case. You may not arbitrarily disregard believable testimony of a witness. However, after you've considered all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances of the case, you may decide which witnesses are more believable and weigh their testimony accordingly. All right. Call closing argument.
Thank you, Mark.
Please do.
6 years ago today, on June the 25th of 2019, the defendant, Justin J. Sales, put into motion his terrible plan. We're here today for these two ladies. What they went through 6 years ago on the 6-year anniversary of that crime. Doris Puleio and Trudy Goetz. We've shown you throughout the trial a timeline of the defendant's activities. You'll have this in a few slides in this presentation, and you also have this in the evidence. And remember, the evidence goes back with you to the jury room. Go through the evidence. Take time with the evidence. Look at each and every piece. But specifically drawing your attention, you'll remember that on June 24th of 2019, the day before the murder, the defendant is there prepping. He's there scouting at 11:10 p.m. He's at 210 Bob White Road, which is the residence of Doris and Trudy. You can follow his actions. You know that he is there at roughly the same time the next night, 11:22 p.m. And this is the night of the murder, June 25th, 2019. He's back at 210 Bobwhite. You'll remember, so he's there at 11:22. You'll remember that 11:39, that's when the 911 call is made. And then he returns to his home at 11:42, 1.6 miles away. We'll walk through this timeline with a few more slides. So, focusing first on the day before the homicide. This is the prep work. This is the scouting out his robbery. You'll remember from Investigator Chris Persons that on June 24th at 11:10, and look at the precision, even the seconds, 53 p.m., so 53 seconds, 11:10 and 53 seconds, he is at his 210 Bobwhite Road, the residence of Doris and Trudy. 29 minutes later, 11:49, he is back at his home, 600 Early Farm Road. Jumping ahead to the day of the homicide and the maiming, June 25th of 2019, again, 6-year anniversary. He's there at his house, 5:57 p.m. Moving forward at 10:09 p.m., he's at Dakota's house, 136 Thacker Lane. He is getting the Glock to hit a lick, and this is the start of his terrible plan. Next, you have him at 600 Early Farm Road at 10:46 p.m. That's back to his house. Remember, Early Farm is the residence of Justin Sales. Then at 11:22 and 34 seconds, that's when he's back at Trudy and Doris's house to hit a lick. Remember, hit a lick is commit a robbery. This was the exact thing he made his terrible plan to do. This is when he murders Doris. This is when he shoots and badly wounds Trudy. Remember that Trudy placed a 911 call at 11:39 p.m. This is just 17 minutes after the GPS places the defendant at her home. Heroically, you'll remember with that 911 call, Trudy composes herself after being shot enough to make that 911 call and get help in motion. And then, you return home 11:42, Early Farm, after committing the murder. So we're going to go through just a few of the crime scene photos, but remember, all of the evidence is available for you. You can go off your memory of it, you can go off your notes of it, but all of that evidence will go back to you to the jury room. But here's a few things. The defendant clearly shot from outside the house. You can see from the picture, the shots come from outside the house to inside the house. The defendant had the cover of darkness and the element of surprise. Remember, this is where Trudy was sitting on the couch watching television. Again, shots from the outside into the house. This, of course, is the shots into the bedroom where Doris was sleeping. And this is a photo of the inside of the room. And you remember, and some of them will come up here, some of the pictures are harder to look at. And but still, we have to show what happened. And so we can't avoid things even if they're difficult to look at. This is how Doris was found when law enforcement made it into the house. This is one of Trudy's wounds when she's at the hospital that night. And remember, she had scarring. This is just one of the images of her scarring. You'll also have the other evidence of her injuries from her testimony and from the pictures when you look at all of it. And you'll remember the crime scene was processed by then investigator Clay Thompson, now Captain Clay Thompson. And you remember the first 8 items he collected were the shell casings from the Glock 40 caliber, from the murder weapon. When first collected, you knew they were from the murder weapon, but didn't know what the murder weapon was. Then you heard from the ATF later, of course, connecting them to the firearm, which identified which murder weapon it was. And you'll remember that the ATF, for some reason, does not call them items. The ATF calls them exhibits, but it's the same thing, 1 through 8. those casings match the Glock 22 40 caliber murder weapon with the green laser light. You remember, when you go through this, we're not going to do it all here, but 1 through 8, we went through all of them. Captain Thompson collected all of them. So he collected them and documented 1 through 8. And then the autopsy, we won't focus a lot of time here. It's not really, it is an element you have to determine what she killed. It's not really in dispute, but you'll remember from the autopsy, and this is just a little zoomed in excerpt of it, that gunshot wound to the torso and manner of death was homicide. Of course, you'll remember from the autopsy and the testimony that the lethal wound was when she was shot in the back from the defendant. Remember the autopsy, and I'll go through these quickly, but she had to be taken there because at this point, it's difficult as it is, she had to be processed as evidence. You know, it's hard to think of a human process as evidence, but that's the process that has to happen. And everything was documented and reported and tags used. Of course, now we get to the murder weapon. Remember there was a short video of the defendant shooting the murder weapon?
Okay. He's a fool.
You see the green laser light, and at the start of that video, which you can go back and look at later, but you can see Dakota, and he testified, he's wearing that fanny pack. That's the strap of his fanny pack in that video. Of course, on the floor, when they go do the search warrant, when they do the 136 Thacker Lane search warrant on July the 2nd of 2019, the attack team enters, flashbangs, big production. They get in there and see a green laser light through the smoke and trace the laser back to what ends up being learned is the murder weapon. That's how it was found, and you will note in the picture there's the strap of the fanny pack from the previous video. So multiple photos were taken of the murder weapon still laying on the floor inside the house. Multiple photos. And a zoomed in photo showing the serial number BAWB 711, as you remember and heard over and over again. So let's show you that. You know that it was the serial number on the firearm itself when it's collected off the floor. You know it's the serial number on the box that was collected in Dakota's house. You know it was the serial number written on the evidence box when it was processed, and the evidence label, and the ATF report. The advantage of the ATF report is our expert, Jody Marcinopoli, testified that the serial number had not been altered. If you zoom in on her report, of course it lists the serial number that we know matches all of the other elements. The firearm from the house is the firearm that was processed by the ATF lab. So then we start walking through other evidence that was collected. This is item 1, of course items 1 through 8 are the shell casings from the murder.
Hold us just a second so we can consider a bottle of water. Thank you.
Thank you.
Go ahead, Mr.
Show you item 1 here, of course item 1 through 8 for the shell casings collected from the murder scene. This is what you saw Captain Thompson walk through as he was testifying, and that they were fired by the Glock 40 with the green laser. Of course, these were collected and sent to the lab. And the lab, of course, came up in her report, and of course she went through all her expert credentials. In her report, there exists agreement of all discernible class characteristics and sufficient agreement of individual characteristics to identify 1 through 8 as having been fired in the Exhibit 27 Glock firearm. Of course, Exhibit 27 Glock firearm is the Glock Model 22 40 caliber with the green laser light that was the subject of so much evidence and testimony in this trial. Then, of course, more cartridge casings were sent. This was from the search warrant of Early Farm Road. From the search warrant, remember the discussion of 598 and 600 Early Farm Road, and they shared a yard, and they did the shooting range, and we showed you the pictures of the boat that had been shot, and the washing machine that had been shot where they would shoot, and also where that video took place. So shooting there. Items 40 through 44 were collected there and submitted to the ATF lab as well. And of course, she came to the same conclusion that they had been fired in the Exhibit 27 Glock firearm. Exhibit 27 Glock firearm is the Glock Model 22 40 caliber with the green laser light that we kept discussing. So, we proceeded through the investigation and we get to the control call between Dakota Cash, who you heard from, he was wearing orange, and the defendant, Justin Sales. This was back on July 9th, 2019. It's a 4.5-minute phone call that you can listen to as many times as you want back in the jury room, but we're going to play it once for you here.
That's how we're trying to do it. Because they'll be over here too. That's all I said. Like regular talk. Speak up. You put up here.
Hello? Bro, the fucking police just came to my house, bro, talking about somebody committed a murder with my gun, bro. The police just came to my fucking house, bro, and told me that somebody committed a murder with my gun. Bro, you the only person I gave that bitch to, bro. Bro, put that on everything you love. That shit was not you, bro. Bro, then who the fuck did it then, bro? You the only person that I gave the gun to. Nobody else had it, bro. Like, bro, if you did that shit, just keep it a buck with me, bro. Like, what the fuck? Why would you give that shit back to me if you did that? Bro, then who the fuck did it then, bro? You saying you gave it to somebody else then? Bro, so you telling me they talking about it's my gun that was used, and you the only person I gave it to, bro. I know damn well I didn't do this shit. Like, bro, what the fuck, bro? Bro, you gotta let me know something, bro. This shit crazy. Bro, it's a life sentence, bro. I got 2 fucking kids. Exactly, bro. So what the fuck if you know who the fuck did it, if you gave somebody my shit and you let them do that shit, bro, let me know. Like, what the fuck? You ain't give it, bro, that don't make no damn sense, bro. So you saying it's a murder committed with my shit. You didn't do it, you didn't give it to nobody, but it just happened. Bro, they talking about 2 old women got killed, bro. They talking about 2 old women was shot with my force. Like, bro, you the only motherfucker I gave this shit to, bro. You talking about you, bro. You ain't say nothing about that. You say you was going to rob a motherfucker, bro. You ain't even tell me you hit the lick. You said you ain't do shit with it. Bro, you handed that bitch back to me with 4 bullets left in the gun, bro. You obviously did something, my nigga. Bro, I'm at fucking my grandpa's shop, bro. I'm about to go to Gladstone, bro, before they come and fucking get me. Where you at? Bro, where you trying to meet at, bro? What we meeting for what, bro? Man, alright, bro. Where you want me to meet you at? Alright, bet. It's gonna be a minute, bro, cause I gotta see what Lou doing this shit. Alright.
You'll remember that the louder voice there was Dakota, and Dakota testified and translated some of these things for you that hopefully helped some. We introduced a photograph that you'll remember, and this would just be corroboration that Dakota and Justin did in fact trade guns, because the defendant is not in this photograph anywhere, yet his Draco is prominently displayed in the middle. Dakota testified who the people here are, Trudy, Dakota himself, and Jamari. Testified that the other handgun there was not the Glock, which is a smaller frame gun that's being held in this picture, and there's no laser on it. So just corroboration that they did in fact trade weapons. Now the letter. The letter was key evidence. I'm sure y'all paid attention to that as it came through. The letter from Justin Sales to Hannah Richardson, his girlfriend. You remember that? Dakota read through the letter to you and then helped translate some. I'll just zoom in on some. Defendant, of course, offering to pay. You need people to lie. You need the message passed from Hannah to V and Compton. And then I'll just highlight this area. Tell V and Compton I'll pay them if they do this for me, and I'll be forever grateful to them. But only tell them in person and give them the letter in person. You might be asking yourself, why does truth need secrecy? Then, of course, there were letters included within the letter to Hannah. A letter to Compton and a letter to V. The letter to Compton. Tell them that Ola Williams told you he did it the day before when he came over, and you were hanging out and playing the game. How does he sign it? After you do it, burn this letter. Much love, Justo. Of course, Dakota said Justo is how he signed himself, how he referred to himself, what he was known as. Justo is Justin Sales. It's included in the letter from Justin Sales. You saw in the envelope, and it was written to Hannah, his girlfriend. And you might also be asking yourself, when you tell the truth, why do you burn a letter? So, looking at evidence pointing to the defendant. Hit a lick. Hit a lick came up. It came up from Dakota. It came up in the control call. That's what he was doing. His goal was to hit a lick. We had to have hit a lick. Explain to us what that means. It means commit a robbery, but hit a lick. That's his phrase. So, at Trudy's house, right before the murder. So June 24th, he's already there. He's already been there once, casing the house out, setting up his plan. He's been there once. And you remember, no reason to be there. Her house isn't right on the road. It's more than 200 feet off the road. Long driveway. You saw those pictures. You saw the body camera, and you watched Ryan Watts kind of running up and back down the driveway to move vehicles. You saw this is a long driveway, and he's at Trudy's house the night before the murder. And you remember, there's pins that show you where he is. It doesn't just say generally on that property. It showed you he was at her house, at the front windows where the shots were to occur the next night. So that was the night before. The next point, he's at Trudy's house at the time of the murder. He traded the Draco for the Glock. We know he traded the Draco for the Glock. He even acknowledges that in the control call. He does not dispute, when asked that he wanted the Glock to commit the robbery and murder. He needed a different gun for this. He returned the Glock to Dakota to conceal the murder weapon. He didn't tell Dakota anything. He just gave the murder weapon back to Dakota, who's unsuspecting, not realizing he is now holding a murder weapon. He thinks he's just holding his Glock. There's that control call. We just played it, and I want you, when you go back, I would recommend you do it again. But the control call with Dakota, he admits the gun was solely in his possession. He was even pressed on it. He did not give it to anybody else. Listen to this call again. The murder weapon is solely in the possession of the defendant, Justin J. Sales. And then finally, he closes with offering to pay people to lie for him. So let's walk through it a little bit. GPS. Look at the GPS. Precisely where the shooting occurs. From the house. This walk through jury instructions. The court just read you the jury instructions. You'll have them back with you as well. Take your time with them. You remember all the way back in voir dire when we questioned you, that the jury instructions are the law you apply to the case. It's not what you want the law to be. It's not what you otherwise thought the law was. The jury instructions are the law that you apply to the case. So one of the instructions you got already was presumption of innocence. Another one was reasonable doubt. Some keywords I would just point out here are obviously the word reasonable. It's a key word. And you use your sound judgment as you do this. You weigh the evidence. You apply it to the facts. The Commonwealth is not required to disprove every conceivable circumstance of innocence. It's reasonable doubt based on sound judgment. So we expect you, and that's what you're sworn to do, is use your sound judgment. Then there's a circumstantial evidence instruction. And as the court said, any fact that may be proved by direct evidence may also be proved by circumstantial evidence. And you may draw all reasonable conclusions from the evidence. That is what your job is in this process, is you draw the reasonable conclusions from the evidence. And you can convict the defendant on circumstantial evidence, alone or in combination with other evidence. The evidence as a whole must exclude every reasonable theory of innocence, but it has to be a reasonable theory of innocence. This isn't a time to turn off common sense. This isn't a time to overthink it. It's reasonable. You get to use your judgment. And we have an instruction on your sound judgment, which ultimately gets to use your common sense. But read each instruction. That is the law. Elements of the crimes were read to you as the jury instructions. So we walk through the elements, and I'll walk you through the elements quickly. The first instruction that I'm going to talk about is the aggravated murder one. This is what we would call a waterfall instruction, because there are steps. There are steps to go through. So we're going to walk through that so you understand what you're doing when you get in the back. So aggravated murder has 4 elements. Not all 4 listed there. So that the defendant killed Doris Puleio, that the killing was willful, deliberate, and premeditated. There's also an element of malice, as well as that the killing occurred in the commission of an attempted robbery. The third would be that the killing was malicious, and then 4th should be killing occurred in the commission of an attempted robbery. Justin Sells killed Doris Puleio. That's element 1. That's pretty straightforward. Justin Sells shot and killed Doris Puleio from outside her bedroom window on June 25th, 2019. He was at her house based on the GPS at the time of the murder, and the murder weapon was solely in his possession at the time of the murder, and that the admission that it was solely in his possession is verified by him. You'll have various instructions that help you walk through the elements, describing different things. So read those instructions when you go through specific intent to kill and various instructions. So go through the various instructions. Element number 2, malice is the state of mind. This is element number 3. This is a state of mind which results in the intentional doing of a wrongful act to another without legal excuse or justification at a time when the mind of the actor is under the control of reason. Okay? Getting towards the end, malice may be inferred from any deliberate, willful, or cruel act against another, however sudden. It should be easy to get to this was a cruel act, malicious. Another way you get to malice is it can be inferred from the use of a deadly weapon. You may infer malice from the deliberate use of a deadly weapon. This was clearly the deliberate use of a deadly weapon. Sadly, we know how this ends. So we know it, in fact, we know all firearms are deadly weapons, but in this case, we even know this particular one is a deadly weapon because it, in fact, was the weapon used by the defendant to kill Doris Puleio. So clearly a deadly weapon. But also, the deliberate use. This was clearly deliberate use. 8 shots were fired. You saw the accuracy of those shots. You saw the crime scene photos. You saw that Trudy is struck multiple times, and Doris, 2 shots at her, 2 shots hit her. The one in the back, the shot in the back is the one that killed her. Willful, deliberate, and premeditated. So, willful, deliberate, and premeditated. Premeditation. This is the standard when you hear about first-degree murder. What makes first-degree murder? It's premeditation. But even back in voir dire, Premeditation doesn't have to exist for any particular length of time, but what's important for you is this instruction. The instruction is your law. Premeditation doesn't have to exist for any period of time. Well, we know he shoots at Trudy with 6 rapid shots and then goes and shoots Doris. 8 shots. He has time to decide what he's doing. Well, here you remember we gave the instruction of deciding to change the channel. Premeditation can happen very quickly, and here he did. But we also know he planned this. He planned the attempted robbery, but he planned the attempted robbery with a Glock firearm. He didn't plan to just try to sneak in a house and get something, whatever, I don't need a gun for this, I don't, whatever. He planned specifically to have the Glock Model 22 40 caliber with green laser light because he needed that one. And he planned it at such a level that he knew his Draco wasn't the right gun for the job. He needed this specific other gun. This was a premeditated act. And then the killing occurred in the commission of attempted robbery. That was this terrible plan. We know it was this terrible plan because it starts from the beginning. His plan was to hit a lick. We know his plan was to commit robbery. And we know that he attempted this robbery because he goes there the day before, June 24th of 2019. He's standing outside the window, June 24th of 2019, after 11 p.m. What does he do June 25th? He goes right back to the same spot outside their window and this time shoots into the window. He is definitely attempting his robbery. You are not held to, he is not charged with a completed robbery. He is held with an attempted robbery. His failure to then steal something is not before you. It is, did he take an act to attempt the robbery? And yes, he did. Murdering the 2, shooting at the 2 people, murdering 1, who are inside the house, the 2 witnesses, is an act towards completing a robbery. We don't have to know why he didn't go in to complete it. He attempted it, and that is his charge, is attempt. So first-degree murder, again, this was a waterfall instruction. So you have first-degree murder. You'll notice that first-degree murder does not include the element of during the commission of an attempted robbery. So Commonwealth is presenting to you that we have proved aggravated murder. We have proved he attempted the robbery and then committed the first-degree murder elements within that attempted robbery. That would be aggravated murder. If you find, which is what the instruction says, that he wasn't attempting his robbery, if you find that this was rather first-degree murder, you will not find aggravated murder. You would then find first-degree murder. And this will be the one verdict form that will be different. And the verdict form will have 3 lines. Typically, a verdict form will have 2 lines. The foreperson will sign guilty if they think it's guilty. If y'all all unanimously agree it's guilty, you'll sign the guilty line. If not, you'll sign the not guilty line. That's how guilty and not guilty normal verdict form works. However, this is a waterfall instruction. You will have 3 options, and you will sign. The foreperson will sign on 1 line. If it's aggravated murder, you sign the top line. If it's first-degree murder, you sign the second line. If it's not guilty, then of course you would sign the bottom. But your choices, aggravated and first, you would only sign one of those. So if you find all 4 elements, that's aggravated murder. You don't then think, well, I found all 3 for first degree also, let's sign both. You go down the line. You find all 4, you sign the top line. Aggravated murder. Of course, that's the Commonwealth's position, is that's the evidence we have put before you over the last 2 days. Of course, same argument for first degree murder, that those 3 elements would be met. So next, once you have decided the murder, you'll have aggravated malicious wounding. Aggravated malicious wounding, the defendant shot Ann Trudy Goetz. Of course, you know Ann Goetz is Trudy Goetz, and we call her Trudy. So the defendant shot Trudy. That's pretty clear. You saw the scarring, and then you saw the hospital photos. She was clearly shot. You saw the body cam video where she's very obviously bleeding. You heard the testimony of the people that were there first. Major Begley specifically said, yes, she was obviously injured. That was visible at the time. So, defendant shot Trudy. Such shooting was with the intent to kill or permanently maim, disfigure, disable Trudy. Well, that's an easy box to check as well, because he fired 6 shots at her, striking her multiple times. That the act was done with malice. That'd be the same malice instruction as before. It can be inferred from that deadly weapon. And it also, the language about cruelty. This was clearly a cruel act. But as a result of the act, in element 4, Trudy was severely injured and that was caused to suffer permanent and significant physical impairment. You heard her testimony. She spent 6 days in the hospital. You heard her 911 call and her breathing through that. The 6 days in the hospital, you saw the gunshot wounds, you saw the holes, and then you saw the scarring, which not only was the scarring there later, once it had, the scars had healed over, the scars were visible, and you saw those, but you also heard her testimony that she still carries those permanent scars to this day. So we check off each of the 4 elements of aggravated malicious wounding. So shot, hurt, this, of course, it's duplicate type evidence because the shooting of one happened at all the same details of the same place, the same times, the same motive, the same everything. But he was there at the house to hit a lick, and he is there, GPS putting him at the front of the house where the shots were fired. Again, look closely at those pictures and those with the GPS embedded on it. You remember her injuries we just described? Made with the intent to kill. Well, Trudy and Doris were totally unaware that Sales, the defendant, was outside in the dark. Completely and totally unaware, with no warning. The defendant, Justin Sales, shot at Trudy Goetz 6 times with a .40 caliber handgun. Element 3, of course, as we described, you may infer the malice. Element 4, severe injury, bullet wounds to her chest and back, spent 6 days in the hospital, significant permanent scarring. You remember the scarring photo? So use of the firearm while committing aggravated malicious wounding. The defendant used the firearm, and that was used. That use occurred while the defendant was committing or attempting to commit aggravated malicious wounding. Those are both boxes are very easily checked. Of course, you know that he used the firearm, and you know that it was during the aggravated malicious wounding. You know that happened. You find the other it was with the Glock 22 40 caliber green laser. The 6 casings found outside. You remember that. Aggravated malicious wounding. Of course, you know that. You would have already found that with the crime itself. Then you have use of the firearm in the commission of murder. Well, you did use the firearm to commit the murder. Again, you find the murder. You know she was murdered with a gunshot wound to the back. You find the firearm. So you actually find guilty of these as well. Those elements are easy to check. Then you have shooting in an occupied building. Then the defendant shot at a building that was occupied by 1 or more persons, that the life or lives of such persons may have been put in peril, and that the act was done with malice. Well, that is super easy. That would be true even if we didn't have the benefit of hindsight, but of course with the benefit of hindsight, we know that he shot from outside the building, occupied by 1 or more persons. We know that he would have even known it was occupied by 1 or more persons because the light was on inside and he's outside in the dark, so he sees in and shoots 6 times at Trudy and twice at Doris, killing her. So we know he shot from outside. And both of the shots we know were shot from outside, and as was clear at trial, no evidence he ever went inside. He was shooting from outside the clearly occupied building. And of course, the shooting was done with malice. Same malice as before. He inferred from the firearm and inferred from the cruel act. Now we have attempted robbery. Attempted robbery, we know this all started. His terrible plan was to hit a lick. This was how this whole thing started. This was why this whole thing started. We know it was while using a firearm. That's all the evidence that you have before you. Casings outside, the 6 shots in one window, the 2 in another. You know that he did that, and you know that there's a direct act. Because the direct act, he has to sneak up to the house in the dark. They have no idea he's there. He's already cased it the day before, and then he fires and kills 1 witness and badly injures another. He shoots the 2 people that would be witnesses to his robbery. He has done an act towards his robbery. You'll have instructions on what intent, you had instructions on what intent, and you'll have them back there with you, on what intent is, what a direct act is, and that it's not a defense if he voluntarily withdrew before actually committing. It is irrelevant that he did not complete this crime. He is charged with attempt. even if you find that he didn't go in the house, he must have decided not to do it, the law would say even if he voluntarily withdrew at that point for attempt, it is too late. He has attempted this robbery. It is completely and totally irrelevant that he did not complete the robbery. All it has to be is an act that's more than mere preparation. Certainly, based on the injuries to Doris and Trudy, it would be preferable that he only prepare, because a preparation would mean neither of them were shot. They were both shot. So the terrible plan. You know this, we've gone over this. The terrible planning was trading guns. This was part of the plan. He wanted a different gun to hit a lick. He wanted the Glock 40 with the laser. He had already scoped out the target. He had already decided that that Glock 40 caliber is the right gun for this robbery. He had already scoped that out. That was the terrible plan. And then he told Dakota he was going to hit a lick. Confirmed with the phone call later, also testified to by Dakota. They traded guns for him to commit a robbery. So that was the terrible planning. But this terrible plan also had terrible execution. He attempted the robbery, but did not complete it. He used a weapon with a clear serial number. He left the shell casings at the scene that could be traced back to the gun, which identified the murder weapon. He was tracked by GPS to within, as investigator Chris Person said, to just a few feet of him. And you'll notice, again, I want you to look at those pictures that were covered in the slideshow, but they're in evidence. It's even putting him at the house, at the windows where these shots were fired. So he's tracked by the GPS. About an hour after the murder, he downloaded a scanner app to follow what law enforcement was doing. And then he admitted to Dakota he had the gun with him the whole time. So terrible execution of this terrible plan. And then he finishes it with a terrible cover-up. He returned the murder weapon to Dakota, presumably to point towards Dakota if ever discovered. But he certainly did not just get rid of the murder weapon so that we couldn't tie it back to the casings at the scene. And then he tried to pay people to lie. Remember the letters. He tried to pay people to lie. You don't pay people, you don't need to pay people to tell the truth. You don't need to tell people not to burn something that's the truth. You don't need to only talk to someone in person if you're telling the truth. You remember that letter. And then sadly, the terrible plan ended with a terrible result. Trudy Goetz was shot and permanently scarred. Doris Puleio was murdered. So today we're asking you to remember Doris and Trudy as you review the evidence. And please, take your time reviewing all the evidence. But at the end of that, we ask you to find the defendant guilty. We ask you to find the defendant guilty of aggravated murder. We ask you to find the defendant guilty of aggravated malicious wounding of Trudy. We ask you to find the defendant guilty of the attempted robbery. We ask you to find the defendant guilty of shooting into that occupied building. We ask you to find the defendant guilty of both counts of use of a firearm. One use to shoot Doris in the back, the other use to shoot Trudy multiple times. We ask you to find the defendant guilty of each of those charges. Thank you.
All right, that's close to argument.
Thank you, Your Honor.
Ladies and gentlemen, what happened that night was horrible. Awful. And I cannot imagine the pain that Trudy Goetz and the Puleio family is going through. The 911 call Trudy Goetz made was heart-wrenching. I felt a tear. But this is a court of law and a court of fact. This is not a court of emotion. And what I'd like to do is review some of the facts of this case. Because this case, quite frankly, was a problem investigation by the Sheriff's Department from day one. Ms. Goetz was the first person to testify. And she clearly says, she was shot. There's no question about that. She was shot. Her mother died. We're not arguing about any of that. But what does she say? She doesn't know who did it. She didn't hear anything. She didn't see anything. She didn't see the green blazers coming in. Nothing. And this is a house that was dark, where you really couldn't see the inside. The Congress will show you the pictures. But those are all the pictures that lit up by the sheriff's department. This is something that occurs late at night, deep in the woods, dark house where you cannot see the inside. And that becomes important. The second individual who shows up, Ryan Watts. Ryan is an excellent law enforcement officer. Did everything right. He checked, he tries to render first aid. And when we asked him, did you see any damage to the door? Any time of entry? Any time of forced entry into windows? Anything? Anything missing? Nothing. No sign of any kind of robbery, no sign of any kind of break-in, no sign of anything is missing. And Clay Thompson testifies. And Clay, Captain Thompson is a pretty decent officer. I will admit that. And he goes and he collects the shell cases. And that's his primary responsibility to collect shell cases. But then what happens is that he says he takes these shell casings and he drives them to Roanoke. And then he says, well, the next day I'll go back, I'll pick up these shell casings, and I go with ATF agent Russell Davidson up to the ATF lab in Maryland to drop off the shell cases. That's what he writes down. Quite frankly, I don't get to this. Teresa Mays, who does the evidence clerk, also talks about that. But what she says is that the shell casings went to Clay, and that he returns them. That who checks them out? Not him, not Clay Thompson, but ATF agent Davidson is the one who checks them out, which is contrary to what Captain Thompson says. So we have inconsistencies about how they're handling the evidence. Captain Thompson says that Robbie Oliver was the lead investigator in this case. And he had this entire case for 2 years before he was ultimately terminated. And in 2 years, Robbie Oliver wrote 1 paragraph of a report of a homicide, malicious wounding, shooting case. 1 paragraph in 2 years. That shows what the Sheriff's Department is really doing in this case. He says, when we arrested Mr. Sage, we seized the phone. And what do? Give that phone to Robbie Oliver. I'll talk about Robbie in a minute. But where's that phone? God only knows. Because Investigator Oliver, when questioned about the phone specifically, says, may have got it, may not. He didn't care. A vital piece of evidence in a homicide case, and the lead investigator doesn't care how he treats evidence at all, and quite frankly, doesn't even take responsibility for what he does in this case. We talked to Captain Thompson about 600 Early Farm Road. He said, oh yeah, Justin Sells lives there. Who else lives there? Anna Richardson, his girlfriend. Who else? Christy Sales, his mother, who, according to Captain Thompson, is a wanted fugitive, and left after this. And you want to know what else doesn't happen in this investigation? There is not a single shred of evidence that they interviewed Christy Sales about any of this. And the reason that is important is because Mr. Carver says, oh, well, Justin Sales is at this residence. He's at 210 Bob White Street. No. What they're saying is, there is a GPS tracking your Facebook that is there. And whose Facebook is it? It's Christy Sales. Not Justin Sales, it's Christy Sales. But they don't want to say that, because they know that's doubt. And we don't even want to talk about Christy Sales, despite the fact that she lives at the house with Justin Sales. She has access to the firearm. She was at 136 Thacker when the raid was made and the Glock firearm was seized. And now she's a felon or a fugitive in flight. But we don't want to talk about that. Jamie Begley, Major Begley. He says we do the search, and Christy Sales is also present. And then this firearm, this Glock firearm that is found, is located at the scene. Now, the Glock firearm, we do not contest that it's not the murder weapon. It is the murder weapon. We know it's the murder weapon. We have said so. We don't doubt that. And we don't doubt that it's Dakota's firearm. We don't doubt that it was at Dakota's house. But the problem that we then run into is that Sam Bryant, a Vatican deputy with the sheriff's department, goes and says, he sees this Glock firearm, and he turns it over to someone from the ATF. And he describes it. He was wearing a red polo shirt with an ATF sticker sewn on badge on the polo shirt, that the agent made the firearm clear. So he empties it, empties the magazine, make sure there's nothing in the chamber, and he ties it off to make it safe and puts it in a box. That's what his testimony was. He was very specific about that. And then the next witness we hear from is ATF Special Agent Russell Davidson. And Special Agent Davidson talked about how hard it was to get into the ATF. All the things that you have to go through. That if you made an error in things, you bounce a check, you can get fired for that. They take that seriously about errors and what they do. And he shows up with a stack of reports. He said, everything that I did, I got a report. Unlike Amherst, I've got a report. And when we questioned him, what does he say? I never touched that firearm at the scene, ever. He never transported it to the sheriff's department. He said, did you tie it off, make it safe? No. Did you hand it to anybody? No. He said, even the description of how you're dressed, he goes, I would never, at a search like this, wear a polo shirt. He goes, as he puts it, kid up, which is you wear your tactical vest. He goes, never would I ever show up in a polo shirt, in a search like this, which is exactly the opposite of what Amherst is saying. It is not a mistake. Mr. Farmer's, voir dire initially spoke about, well, there might be some mistakes. This is not a mistake. This is a clear black and white. Amherst deputy says one thing, ATF that he identifies as taking the gun says, not me, didn't happen. That is not an inconsistency. And I hate to say this about law enforcement, I really do. I've worked with people for years. But the law enforcement officers in this case, there was a lie. And I hate to say it. But the law enforcement officers in this case are lying. Pure and simple. I can't tell you, we know there's a lie about this gun. I can't tell you if there's lies about anything else. But we know that there are lies that are going on. finally get to Robbie Oliver. Mr. Oliver, at this point, is terminated from the sheriff's department. Why? We don't know, but he's terminated. He says he wrote many reports, which is contrary to what Clay Thompson says and what Chris Person says. He came in and reviewed and said, well, there might be a little more than just a paragraph, but not many, and there's not much there. So we know once again, Robbie Oliver isn't exactly being accurate about what he did in this case. He says, well, I remember doing an interview with Dakota, but I really don't remember doing an interview with anybody else that we picked up in this raid. Once again, not even caring that he's not doing his job. He does say, I never touched that car, until the next day, when I entered into evidence. But even he said, I have no clue how that gets to the sheriff's department. None at all. He talks about the phone. We spoke about that. He says, may have gotten it, may not, but Clay Thompson was very clear. He's going to give it to Robbie Oliver. And where does it go from there? God only knows. The sheriff's department said we searched high and low, and it is not there. And all we know is that when Robbie Oliver got terminated, he cleaned out his office. And presumably, that's where you keep it. And if that occurs, he doesn't even have the decency or the integrity that you expect from an officer to say, hey, I took this accidentally, here it is. No, it's just missing. Now, he says he goes to the ATF with Russell Davidson and drops off the gun and shell cases, which is actually what Russell Davidson says, which is definitely contrary to what Captain Thompson says. So even there we have inconsistencies about what's going on here. When we get to the ATF lab, yeah, they do a check on the firearm and they say, yes, this is the murder weapon, it's clear, we know that. But then we talk about DNA. And we go through a great deal of very, very boring testimony about DNA. I was falling asleep, probably all were too. But basically, DNA is unique. I've used this water bottle, my DNA is all over it. You take it to a lab, they match it up, it's me. And they say, we do DNA on the shell casings. And whose DNA we found on the shell casings that were found at the murder scene? DNA belonged to Dakota Cash and Jamari Stewart. Who do we not have DNA on at the murder scene? Justin Sales. They talk about the firearm. We do DNA on the firearm. Lots of DNA. We know Dakota's DNA is on it. But whose DNA is not on this murder weapon? Justin Sales. Mr. Parker doesn't want to talk about that in his closing. Then we get to Dakota. And I will admit, they went and they, told everybody up front he's going to show up in orange. But they don't want to say, oh yeah, by the way, he's awaiting trial for attempted capital murder of 2 law enforcement officers, Amherst County officers. And how long has he been waiting trial? 4 years. He's been sitting in that Amherst jail cell for 4 years, waiting for his chance to come up here and talk about stuff. He said, oh, well, nothing's been promised to me, but I'm hoping that the Commonwealth is going to give me some sort of break. He's expecting something, and quite frankly, even though if it's not spelled out, it's implied. There's a deal out there. I've done this for years. I understand what that means. He's expecting something in exchange for his testimony, and he's got something to gain from it. And he says, I gave this gun to Justin Sales, and we don't doubt that. He did. But when he gets it back, he talks about two different things. He says, first, Justin returned it to me at my grandfather's house in person. Drumheller asked him that specifically. Was this in person? Yes, it was. And then the very next thing that occurs is they play a message that says that Mr. Sales left for cash. That I'm getting the Drake and I'm leaving the Glizzy. And they said the Glizzy is the clock, slang for the clock. Which is contrary to what Dakota Cash just said moments before in his testimony. When he testified at a grand jury, he stated that Justin Sales loaded the Glock firearm himself before he took it. He didn't. Now at trial he said, well, I really don't remember now. Because the problem is that if Justin Sales loaded the Glock himself, why isn't his DNA on the shell cases? You know, that the ATF analyzed. And more importantly, why is Dakota Cash's and Jamar Stewart's DNA on those shell cases? So they don't, they can't explain that. Now, he also talks about that when the raid takes place, that he has this gun in his backpack, or this fanny pack. You know, you saw the movie there, this yellow thing. But what does he say? He said, I throw this onto the ground. The whole thing, I throw it onto the ground. But yet, when the search is made, this firearm is not in a fanny pack. This firearm is out. So once again, the statement is incorrect with what's going on. We keep on talking about this lick. Allegedly, Mr. Sales spoke about with Dakota. There was supposed to be a lick. But what the lick was, and we cut it off, he said it was a lick for a marijuana dealer. That's what it was. Yeah, I'm not telling you that Chuck Bill was a corrupt guy. But a lick for a marijuana dealer is very different than what the Commonwealth was saying that he did. And quite frankly, if the plan was to go to the Goetz house and you're outside, why would you need something smaller? Why would you need to trade a firearm, a pistol, for a longer, rifle or larger pistol? The answer is you wouldn't. So there obviously was no plan to go there. That was not what was going on. But yet, what they're doing is they're taking one snippet of the conversation and trying to say, well, we want you to expand this days forward. And you can't. Now, I will admit, he comes in and he says, I reviewed this letter that Justin Sales wrote, and that letter is very damning. I'm not going to lie to you about it. And in that letter, you can read it. And Justin Sales says, he goes, I've been in jail for a year. And he's desperate. Because he knows that the Commonwealth has decided he's the guy. In fact, they decided that Investigator Oliver set up right at the scene before any evidence and said, I think Justin Sales did this. So he knew that they were out to get it right from day one. If he did something that was stupid and desperate. I'm not going to deny it. It's the most idiotic thing I've seen in a long time. I see it a lot. But desperate people do desperate things, especially when they're trying to help themselves, and especially when they also know that their mother, Kristen Sales, might also be involved in this. The one thing that the Commonwealth doesn't ask people, and this sort of surprised me, is that they never ask you, where were you? Where were you when this homicide occurs? It's your gun. It's your DNA that's at the scene. Where were you? No explanation whatsoever of about what was going on. There was no type of alibi for Dakota at all. We finished with Chris Persons. Chris Persons is an excellent investigator. No question all about it. Amherst was lucky to get him. But Chris Persons was very clear. He said, I did tracking through Facebook. So he's not saying Justin Sales was there. He's saying a phone was there. And when we asked, he said it was not Justin's Facebook, it was Christy Sales' Facebook. And they had access to Justin Sales' Facebook. Quite frankly, if you have access to his Facebook, why isn't there PowerPoint saying this is from Justin Sales' Facebook? Because they don't want that. Because they want it to be here. They do not want to talk about Christy Sales at all. Now, I reviewed the evidence. And you also, copious notes about this. This is a long trial. And the court has read instructions, which is the law. And this is what I talk a little bit about. Because what we start off with, either aggravated murder or first degree murder, it's the same problem. What they're saying is that Justin Sales willfully, deliberately, and premeditated killed Charles Clark. And it's the same instruction for the aggravated murder that he intentionally, with the intent to maim or kill, permanently disfigure, or disable the death. It's intent. It's an intent issue. Because what they're trying to say is some individual, anything is just but some individual will not see into this house on a dark night, shoots into a house that had the intention of killing someone, had the intention of permanently maiming someone. That's their burden, that they got to prove that he intentionally did this. And that was his intent, to kill, not shoot into a house, but to kill, or to aggravatedly, maliciously wound. That's the Commonwealth's burden. The second thing, second instruction, is we talk about circumstantial evidence. This case is nothing but circumstantial evidence. Mr. Farber gave an illustration about, well, if you go out there and you had a mailbox, go out half an hour later, mailbox is gone, well, something happened. That's circumstantial. But the instruction also reads that when you rely on circumstantial evidence, the evidence as a whole must exclude every reasonable theory of innocence. Every reasonable theory of innocence. And this is where the Commonwealth, quite frankly, really falls in. Because they know that Christy Sales is a viable suspect. They know that Christy Sales has access to this gun. They know that Christy Sales was present when that search was made. They know that Christy Sales' Facebook is at 210 Bob White Road when this homicide occurs. They know that her Facebook was there the day before. And what do they do to try and rule out Christy Sales? Nothing. Absolutely nothing, which is their burden of proof. And quite frankly, on that fact alone, you can find Justin Sales not guilty of these offenses. So what do we have in the end? We have a lead investigator quite frankly, he was totally incompetent. I mean, there's no way around it. He was totally incompetent in this. He gets fired, doesn't even care what happened to the evidence. We are trying to rely solely on circumstantial evidence, and we keep on saying just sales, knowing full well that could just as easily have been Christie sales. We don't want to talk about that. And then we're talking about the differences in sworn testimony by law enforcement officers, where it is clear that an officer in this investigation is lying. And I don't say that lightly, but that's what it is. Someone is lying. And the problem is that when you rely upon testimony that you know is perjury, it makes a mockery of what we do here every single day. I understand the need for justice. I understand. But we cannot sacrifice individuals on the altar of vengeance and call it justice.
Calls for photo argument. Thank you. Justin Sales had a terrible plan he put into motion 6 years ago today. Make no mistake, this was a plan. This was a plan. His plan was to hit a lick. His plan was to trade guns with Dakota so that he could conceal it more easily because he wanted a smaller gun, a green laser, whatever. What goes unsaid in this is, why would you want a green laser? Well, he had been there the night before, so he knows it's dark. He knows it's back in the woods. He switches to the gun with the green laser to go back. He knew which gun he needed because he had been there the night before. He knew which gun was right for this. Defense counsel wanted to argue that why would you switch? The Draco was better. It's hard to say which one's better, having not planned a robbery, which one is better. But it stands to reason that a green laser helps you shoot at night from the dark. So let's talk about the dark. The defendant used the dark to his advantage. He was able to sneak up on the house, which is more than 200 feet off the road. Trudy testified, you heard her testify, she did not hear or see anything. He was able to sneak up under the concealing aspects of darkness and sneak up on them. And then he was able to start his attempt at that robbery. The intent, unfortunately, changed to murder, and premeditation, remember, didn't need to exist for any length of time. He started with a robbery, he switched to murder. He intentionally shot and killed Doris and shot and badly wounded Trudy. He did this with intent. He did this as part of his terrible plan. In the video you saw with Dakota, we played it as part of closing. You saw it in evidence. You can watch it again as many times as you need to in the back. He's shooting in very low light conditions then as well. The defendant is shooting the same gun with the same green laser in that as well. This is all part of his terrible plan to hit a lick. It was his plan and his decision. Doesn't matter if we might think, oh, the Draco might have been better for some tactical reason. I don't know. I haven't planned a robbery. But he did plan a robbery, and he thought the green laser was better to hit a lick. So he went for the different firearm. We want to be confident in our homes, just as Trudy and Doris were. As you can see from the pictures, they were comfortable in their homes because they didn't have the blinds drawn, they didn't have curtains drawn. I can't say which window treatments they had because the windows were open. The windows were clear. The shots went through, and they documented everywhere the shots went. So if the shots had gone through a closed curtain, that would have been documented, just like the holes in the wall were documented, the holes in the couch were documented. So the holes in the screen and the window were documented. All of these things are documented. So the windows were open. They were confident in their homes, and even so, the defendant was able to sneak in the dark. Was he able to see? He's in the dark. They are in the light, at least more light than him. And we know Doris was asleep, so she certainly didn't see. Trudy was awake, sitting on the couch watching TV, so illuminated by the TV, and remember her testimony. There was a lamp on. This isn't law enforcement flipping the lights on later. There was a lamp on and a TV on when Trudy was there. So, yes, it was dark, but not dark where the defendant couldn't see, just dark where the victims could not see. They could not see their attacker. We teach our kids not to be afraid of the dark, so let's not let this story get out. Christy Sales. He wants to talk about Christy Sales. Christy Sales was not a viable suspect. There's a long list of reasons she's not a viable suspect, but we can point to one that just 100% absolutely takes her out of the equation entirely. The murderer was tracked for his arrest with the number 1519 that wants to be pointed to, defense wants to point to Christy Sales on her Facebook. It was tracked with 1519. Defendant was tracked with that number to Littleton Lane. And was asked who was at Littleton Lane. Christy Sales was not at Littleton Lane. The phone was obviously there, because that's how they tracked him there. It was by the phone, 1519, and Christy was not there. The defendant was using that phone. It doesn't matter whose account it was in, it doesn't matter whose, whatever, that doesn't matter. We put that phone in the defendant's hands. And we even called Ashley McPherson. She was the very brief witness and might have been for a moment like, why in the world, what did she add to this case? She corroborated the GPS. Ashley McPherson described where she was in Lynchburg, needing to be picked up, the times, everything, and lo and behold, those match what the GPS that defense wants to say is Christy Sales, but Justin Sales, not Christy Sales, is who went and picked up Ashley McPherson. So that little detail that might have seemed inconsequential is actually a huge piece to this puzzle. It's yet another corroboration that this GPS data can be relied upon, and you can and should rely on this GPS data because this GPS data is tracking the defendant, Justin Sales. It is not tracking his mom, Christy Sales. Defense wanted to say that we should have had her here as a witness and we should have whatever. Fugitives don't just come to be witnesses. That's not how this works. Like, so her being a fugitive makes it seem like, oh, it must have been her. Well, fugitives don't just automatically come to court to testify. So we talked about Christy Sales. We talked about the dark. Oh, defense counsel wanted to talk about DNA. So he got to go through the DNA with you, and words he used were boring. And another word he used was that he was falling asleep himself. Well, I hope y'all weren't falling asleep and you got to follow it, the DNA, because the DNA had some interesting points. Now, it's 19 pages, and you'll get to look at all of it. I'm not saying the entire thing was interesting or real fun reading, but it is 19 pages. You get to look at all of that, and I want you to pay attention to the DNA. The defense attorney specifically said that I, talking about me, the prosecutor, does not want to talk about DNA. I very much do want to talk about DNA, and we're going to talk about DNA right now. The video, you saw a video of the defendant, Justin Sales, shooting the murder weapon. Unquestioned, he is shooting the murder weapon prior to the murder. Well, DNA comes back, and he's like, they have no DNA on his, his DNA is not on this gun. His DNA is not on this gun. That might be mildly helpful if we didn't know for a fact he had previously shot that gun. So not having DNA, and that's what we talked about even at voir dire, it's not like TV, it's not fiction. In the hour of the episode, you don't get magically every answer you could possibly want. That's not how it works. The evidence is what the evidence is. And the evidence here is his DNA did not show up in a way that would be helpful to the Commonwealth to prove it in that sense. But it showed up mighty helpful that DNA isn't automatically there. Because we can prove DNA isn't automatically there by the defendant himself. Because we know, without question, he shot that murder weapon previously, because it's on video. You watched it today, you watched it before, hopefully you'll watch it again in the back. He shot that murder weapon, his DNA is not there. That's because DNA sometimes isn't there. And the expert talked about, well, DNA can be wiped off, DNA, you can wear gloves. Like, we don't have an answer as to why his DNA isn't there, but we know his DNA isn't, and we know he has shot that gun previously, even before we get to this trial and the evidence we've produced, which says he also shot it 8 times at Doris and Trudy. We know that he shot there also, but even before that, unquestioned by defense, he shot the murder weapon. His DNA is not on the gun. So all the DNA, and go through the DNA. It's 19 pages. You'll see that it doesn't even fully exclude Doris and Trudy. Well, we know Doris and Trudy had nothing to do with the gun. They had nothing to do with the casings. We know that. But when you get into science and you start talking into the 1 in 6 or the 1 in a trillion she talked about, we got all the way to trillions. When you talk about these crazy numbers, they weren't even able to fully exclude there. So DNA is complex. It is complicated. But I think it should be in a situation where everyone can agree Doris and Trudy never touched the gun or the cartridges. Because the defendant, undisputed even in defense argument, he never forced entry into the house. He didn't go inside so they couldn't huff. The casing stayed outside. The gun stayed outside in the defendant's hand, sadly. And somehow, in the science and trillions and all that the DNA expert talked about, you heard it all and you can see the 19 pages, they couldn't even be fully excluded. So the DNA shows that defense counsel wants to argue law enforcement was terrible. Law enforcement was terrible. Law enforcement still did all the steps, and DNA is one of the steps. So we were able to show you this was done. Did we get the answer that you would hope in your hour episode of CSI? No, you don't get that, but that's real life. And we talked about that back at jury selection. In real life, you don't just get the automatic answer every time, right? So you have to put it together with the other evidence, which is what we've done and what we've gone through, is putting it together with the other evidence. So the ballistics, let's talk about the ballistics. So we just talked about TV and science isn't like TV and stuff like that, real life versus fiction. We got pretty close with the ATF lab on the ballistics because they got the results back so quickly. That's as close as our level will ever get. The nonfiction version will ever get is the ATF lab in this case. Jody Marcinopoli was impressive, and she got the stuff back to match the case, which obviously helped. So DNA, we didn't get it. Ballistics, we did get pretty close to the TV world. So that was helpful, but the ballistics there clearly say we have the murder weapon. That's just not a question. The phone, lots made of the phone. The 1519 phone was the phone the defendant was carrying. The GPS from that phone, from that device, Christy Sales just wasn't there. We already talked about it. She was not there. She could not have been there. If she was carrying the phone at the arrest, she would have been at Littleton Lane at the arrest. Testimony was clear. Christy Sales was not at Littleton Lane on the arrest when they tracked the 1519 phone there. Ashley McPherson, as we talked about, GPS put that device in Lynchburg in the same area at the same time that she's being picked up by the defendant. These things corroborate. It's just more corroboration. And you know why corroboration works? You know why this works? Because the only thing that stands up to scrutiny is the truth. So that's why these little pieces that seem insignificant still fit, because it is the truth of what happened here. How else do we know the 1519 phone was his? The Apple ID records that were admitted through Chris Persons. Apple ID records in evidence go to the email of Justin J. Sales, Apple ID, and not Christy, goes to that. That phone was used to download the police scanner app about an hour after the attempted robbery and aggravated malicious wounding and sadly murder. It was the defendant's Apple ID that was used to download that. Look at the times on that document. When you look at the Apple ID document, and remember that it's Pacific time, so that's 3 hours difference. So had we actually started at 9 a.m., it would have been 6 a.m. out on the West Coast where the Pacific time is. 3 hours difference. So the crux of the defense argument was law enforcement mistakes. And were there mistakes? Yes. The Commonwealth has owned the mistakes. The witnesses, for the most part, have owned the mistakes. Mistakes were made. And that's why we asked all the way back at the beginning, do you understand that a mistake by one does not necessarily negate the efforts by the other? Because you saw some impressive efforts by other law enforcement officers. Ending with Chris Persons, who in early January of 2023 put this all back together as he testified to. He was assigned as the former lieutenant in charge of the Violent Crimes Division at Hampton Police Department. So familiar with this, 15 years doing all that stuff he talked about. He came to put it all back together. And he did that. He said he could work up to 32 hours. This was his primary job. And he just started putting it back together. And sadly, as he explained, some of what he put back together should have been known in 2019. Mistakes were made. But that does not change that the defendant is guilty of these crimes. Because the investigation was put back together. The mistakes were corrected and worked around. And we got to the point where today the evidence is before you, enough evidence is before you to convict the defendant of every crime charged. Robbie Oliver. So Robbie Oliver was the main point of attack. Robbie was being attacked. Robbie testified, and you heard him testify. He testified that he has not worked on this case in a couple years, and he does not have access to his files anymore, which is unfortunate for him because as he's being attacked, he can't even be the one to defend himself. He doesn't have access to any of his materials. He's just going off memory. He's doing the best he can. He said he was here to the case he started. He wanted to see through to the end, so he still came, even though he testified he's not working anymore. He's disabled. Even through his disability, he came and did the best to his memory. Does it seem like mistakes were certainly made in that investigation, and they can be pointed at Robbie Oliver? Yes. He couldn't even defend himself here. So this case had to be put back together in large part separate from Robbie Oliver. He was no longer an investigator. You couldn't say, hey, Robbie, what happened to this? He wasn't here anymore. So Chris Persons had to put it back together. Captain Clay Thompson, who was then the captain of investigations in charge of all of this, had to put it back together, and thankfully so. But Robbie, to his credit, was candid. When he was asked even the collection of the cell phone, he didn't deny that what Captain Thompson said could be true. It probably was true. He just didn't remember it. He didn't remember that he received a cell phone wrapped in aluminum foil that was given to him at Hardee's. It could be true. Debriefings like that can happen. Handing the evidence to him because he was the lead investigator on this case and was the digital evidence guru. Guru is not the right term, just what I call him. The digital evidence guru for the sheriff's office at the time. That was his job. So he would be the person Captain Thompson, then Investigator Thompson, would have handed it to. Robbie does not remember it, does not know what happened to that phone. So it seems like, oh my gosh, we lost a phone. It's terrible. It's the end of the world. Well, two things. One is Chris Persons put everything back together. So you don't have to worry as much about that. But the more important thing is he was not tracked by the phone. This wasn't the phone was dumped and we lost the dump and it, whatever, the Celebrite we talked about. It wasn't that. It wasn't the phone records that did this. It was Facebook records that did this. Facebook. A search warrant of Facebook, not the device. So all of the GPS data, everything we have, we know went to that phone, 1519, and we know came from Facebook, not the phone. No actual evidence of where he was lost when the phone was lost. Do we wish the phone was here today? Of course we do. But does it change any of the evidence before you? Absolutely not. Chris Persons got all the evidence through the other sources. He got the Apple return back, and what do we have in this? He got looked at the Facebook and the GPS through the Facebook. How do we get there? He put it all together separate of the device itself. So the device is actually a red herring. It is a distraction. It is not before you is actually a problem. He mentioned no sign of forced entry on the robbery, and I just want to point out, of course, as we talked about before during the first presentation, we're slide, and I'm talking to you, forced entry is irrelevant to attempted robbery. No, we concede he's not forced entry. I think every witness that was asked would concede there was no forced entry. No theory of this case ever included he forced entry into the house. But that is not an element of attempted robbery. So you can disregard any sort of forced entry. Actually, the evidence makes more sense that he didn't go in because all the evidence is on the outside. The casings are on the outside, the shots through the window are on the outside. It makes more sense that he, in fact, did not go there. Plus, he made it back to his house very quickly because he didn't go in the house. Whatever happened that made him decide, I've murdered, that's enough, and I don't now want to steal their stuff, made him leave. But he attempted the robbery, shot Doris in the back, shot Trudy multiple times before he did leave, unfortunately. So we talk about, there was more discussion of law enforcement and possibly messing up the casings to Roanoke. The casings to Roanoke is strong chain of custody evidence. You heard that paperwork can be prepared in advance. That came out on the witness stand. Paperwork can be prepared in advance. But here's how we know the evidence actually got there. Yes, it went to Roanoke first, to the State Department of Forensic Science Lab. That's where the casings went first, because that is what, at this level, that is where the evidence goes. At Amherst County Sheriff's Office level, it goes to the state lab in Roanoke. That is where the evidence goes. But by the next day, we have ATF Special Agent Russell Davidson. And remember, Russell is a federal agent with access to the federal lab. When the state lab can't do what needs to happen and certainly can't do it quickly, and the ATF lab, as it turns out, can give you some of the results before you get back home, of course, trying to solve what happens. Remember, at the beginning, no leads. No leads in this case. It had to be put together. So Captain Thompson, the same person that takes the casings to the lab, picks them up from the lab, and he goes with Russell Davidson to the ATF lab. You can't get much better chain of custody of evidence than the same person is doing every step. And he testified from the stand, and I believe the exact words from Mr. DeBruin on describing Captain Thompson was, he's actually pretty good, or something like that. But it was at least somewhat complimentary of him, as it should be. He did a great job with this case. So that lab, that evidence went to the lab, is solid evidence. One thing I would say, you're hearing my argument, you heard defense counsel's argument. What you actually rely on is the evidence in this case. You've been taking notes, you saw it, and you will have all the evidence that was admitted back in the room with you. Go through all of it. That is what matters in this case, is the actual evidence. Another attack on law enforcement that we'll touch on before you go back is that we heard Sam Bryant being a little bit criticized, that he didn't see the same thing that Russell saw. So I just want to just point out, Sam Bryant was clear. Sam Bryant, you remember Sam Bryant? He was the former director of public safety. He had 20 plus years in the military. He said, I think 3 years in the FBI. He was a flight paramedic. I'm missing some things, but there was a list of credentials. So he was all those things, and most recently, director of public safety for Amherst County. So he says that when he goes in the house, he's part of the TAC team, right? He's the medic for the TAC team. He goes in and he has to, they go in first. He's the medic at the back to make sure everyone's safe. And then it gets to his turn. Well, there's a toddler there. Oops, we didn't mean to throw the flashbang, but you can't change. You can't unthrow a flashbang. So checks on the kid. Kid's okay. Passes kid back to Captain Davis. He goes on in the house as part of his job as a medic. He sees a green light, traces it back to the firearm, stands over the firearm, and then team leader, Begley, team leader of the SRT, says, stand over that. And he specifically used the term overwatch. Overwatch. You stand over this until it is collected. Sam Bryant says, I stood over it till it was collected, probably 2 hours. He stands over it, and even it sounded like, as he explained later, a little bit to his detriment, apparently he needed to use the restroom, but couldn't until that was done. He stood over it, and he said it was collected by an ATF agent. So, and then later says that ATF agent is Russell Davidson. So, defense counsel told you, and again, the evidence doesn't come from our argument. The evidence comes from what you heard. But he said that Russell Davidson said he never touched it. If you will recall, when asked on direct, Russell Davidson said, when asked if he cleared the firearm, his answer was, not that I recall, and he described seeing the firearm, if you will recall from the evidence. His answer about clearing it, not that I recall. A little bit unusual answer, but he's there. Key thing is, he's there. And then he had some conflicting statements inside the house. I saw the gun, and then when asked, he asked on cross, he said he stayed outside on the perimeter. When defense counsel asked, I don't know why there's a difference there, but I do know Sam Bryant was consistent. I do know he was clear. I do know he was confident. And a lot was made that Russell had amazing credentials, and he does. Federal agents have to go through a lot, as he described. But you know what's forgotten in all of that? Sam Bryant spent over 20 years in the military and 3 years at the FBI, which, oh, by the way, is a federal agency. So we're debating credentials. But you know the advantage we have in this debate? It doesn't really matter, because we know it's the same gun. As we went through the slides before, serial number from running the firearm transaction record from Russell Davidson, that serial number matches that gun. And then, at the crime scene, those casings end up matching that gun later. We know that on the search warrant, while it's still on the floor next to the fanny pack, the strap of the fanny pack, we know that that gun, because you can see the picture taken while it's still on the floor, same serial number on the lab report, same serial on the evidence box, same serial number on the evidence label, same serial number on the search warrant at Dakota's house that just shows the gun box that the gun would have come in, same serial number. The serial number is never in question. And then we just, oh, by the way, our firearms expert is also an expert in serial numbers, as she said, and she says this serial number was not altered. So we know, without question, we have the firearm. Is it unfortunate that no one just says, I picked up the gun, I packaged it, whatever? As Clay Thompson described, Clay Thompson obviously was not there at this scene. Because you saw how he processed the scene. There's a picture from mid-range. There's a picture close up. There's a picture with a scale. Everything is documented. Everything is collected by him. Everything goes to the sheriff's office. Again, Commonwealth can't rise above its evidence. Do we wish that had happened? Of course. Do we wish Clay Thompson was at this scene? Of course. He was not. But the question actually before you is, do you know that this is the same gun? And every piece of this evidence, are we talking about the same firearm, the same Glock Model 22 40 caliber with the green laser light? BAWB 711. Do we know that? Yes. We know that without question. We know that probably you would say at this point ad nauseum. We know that. We know it is the same gun. Chris Persons, well, ballistics gave us the murder weapon. Chris Persons, in a lot of ways, gave us everything else. He's an excellent investigator. I agree, defense counsel. There's moments in these closing arguments that we agree with each other. The defense attorney's words, of course, were that he's an excellent investigator. I agree. I think he said called him a great hire by Amherst. Again, I agree. So Chris Persons put this together. He started putting the puzzle together. He's the one that puts the puzzle pieces, I think is how I described it earlier, of Ashley McPherson. That is a puzzle piece. That is a random little piece. Just something to corroborate. He's the one that put those pieces together. He's the one that mapped all these GPS locations that doesn't just put the defendant at 210 Bob White. It puts him at the house. And it doesn't just put him at the house. It puts him at the windows where the shooting occurred. And puts him there 2 nights in a row at roughly the same time. Casing it out, planning his robbery and later murder, and then committing the murder itself. Chris Persons put that together. Dakota got attacked a little bit by defense counsel's argument. 6 years have passed. Dakota's up there just doing his best to be honest. He did not remember who loaded at that time. It does not matter who loaded the firearm. What matters is the firearm was loaded. And regrettably, when Justin Sales pulled the trigger to shoot Doris and Trudy, it was loaded then. That's when it matters it was loaded, and it was in fact loaded. The thing that, it didn't really come up, but you can piece it together. What matters on if it was loaded is could it hold at least 8? Dakota testified it held 15. Now it probably means it's helpful that 8 plus 4 also is under 15, because if it's true that it was only loaded to 12 or whatever, there was still enough there, but we don't know what he did between committing the murder and the firearm getting back to Dakota when Dakota says there's only 4 rounds in it, which is confirmed, or at least not disputed, in the controlled call. So the defendant's own words or adoptive admission in that phone call, like it's him acknowledging it either by saying it or by not disputing it in that phone call. But either way, whether it's 8 plus 4 or just 8, the gun held 15. And we know the shots were in rapid succession. We know that. Trudy testified about just the chaos of the shots, and you know those happened quick, and then immediately would have gone next to Doris. And it happened in a way that Trudy didn't even realize at that point, and you'll know from like the 911 phone call, she didn't know Doris had been shot. That's how fast these happened. So there wasn't a reload in there. But this firearm, this murder weapon, fully capable of shooting 8 or up to 15 rounds, we know that, and that's how this played out. So that is consistent. He also challenged with Dakota that getting the Drake and leaving the Glizzy, that message was somehow inconsistent with what Dakota testified to, that it got in person. Well, we know, just like we talked about the terrible plan, just like we talked about hitting a lick, he had a plan. Is it surprising that a message is sent that he's going to trade back guns and then he does go trade back guns? Those aren't inconsistent. One would be the plan to trade back guns. One would be the trading them back, which Dakota testified to. Those are completely consistent with each other. So, just to close, I would say Justin Sales had a terrible plan. I've repeated that multiple times. Make no mistake, this was a plan. His plan was to hit a lick. A term you might not have known before this, but now you've heard more times than you want to. He traded guns to a gun he could more easily conceal and to a gun he could more easily shoot in the dark. It has a green laser attached. We know he can shoot it in the dark because he shot in a very low light situation already. And if you pay attention to that, we also know he can shoot rapidly because he shot very rapidly in the video, just like he would have had to have shot very rapidly when he shot Doris in the back and shot Trudy multiple times. We know that he went 2 nights in a row. We know the GPS puts him in the spot he would have shot from 2 nights in a row. You saw the GPS, and you saw that evidence, you know that it is him. The phone can only be his. It cannot be anyone else's. And the murderer here had to have the phone and the gun. That points at one person. There is no reasonable doubt here. It points at one person. It cannot be anyone else. He 100% makes clear, is adamant on the phone call that with the phone call, the control call with Dakota, he is adamant I didn't give it to anyone. He is clear. Liz, please, listen to that phone call again. He is clear. The gun is in his hands. He puts the murder weapon 100% in his hands, cannot be in anyone else's hands. He had it. He made that clear. Now, at the end of that call, Dakota's kind of pressing him on it a little bit, and that's when he's like, well, we just need to talk in person. We can't talk on the phone anymore. Listen to that phone call. It's telling, and it's more telling every time you listen to it. But this case requires two things: the phone in his hand and the gun in his hand. And both are absolutely confirmed, and it's confirmed at the very end when he is arrested, but with that phone number. That phone is tracked. Christy Sales is not there. Justin Sales is. The phone leads us directly to the murderer. The phone that was carried by the murderer, it gets us there. And the very last thing I will remind you of, and I've already said it, is the letter. Read the letter. If you are innocent, if you are just getting someone to tell the truth, why are you offering to pay them? If you are just getting someone to tell the truth for you because you're being wrongfully held or whatever, like, I need to get out of here, or I need to whatever, if that's true and you want the truth told, you don't need to pay anyone. But you also don't need to say, oh, don't just give it to him in person. You know, be secretive about this. You don't need secrecy for truth. You want to shout truth from the mountaintops. But this had to be done in secret. And then it ended with, not just secret, it ended with, and when you're done, burn this letter. Why would anyone ever burn a claim of the truth? Why would anyone ever burn it? You burn it because you know you are guilty. You burn it because you know you had a terrible plan. You burn it because you were going to hit a lick, and whatever happens at that lick, you start it, you attempt that robbery, and you end up, you switch. You switch in there, and you kill Doris. You shoot her in the back, and you shoot Trudy multiple times. That's why you burn a letter, because you know what you did. The defendant knows what he did. Now y'all know what he did, and I ask you to find him guilty of every charge. Thank you.
Members of the jury, as you know, this is an important case to both the Commonwealth and the defendant. Both parties are entitled to a fair trial and your best efforts. You've now heard all the evidence, the court's instructions on the law, and the arguments of counsel. You're about to begin your deliberations. In order to reach a verdict, each of you must agree on that verdict. In other words, your verdict must be unanimous, in writing and signed by your foreperson. The first thing that you should do when you go back to the jury room is to select a foreperson. The role of the foreperson is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. In the jury room, you will have the exhibits that were entered into evidence, you'll have the instructions of the law that I read to you a short time ago, and you'll have the verdict forms. Commonwealth has already explained to you how the verdict forms work, so I won't do that. We will have a computer back there. Some of the evidence is digital. It's on flash drives. We've inspected the computer. There's nothing on there that what you want to see as far as the computer. There's no internet connection. There's no nothing. This is as very basic as it gets. It's ready to go. But you'll have the computer back there in case you want to. I'm not saying you have to watch the videos or the audios, but you'll have that opportunity to do so. You'll also have all the other exhibits. You should discuss the case with your fellow jurors to reach an agreement if you can do so. I suggest that you discuss the evidence and the law to your satisfaction before you take a vote. If you find differences of opinion, and it would be helpful to do so, I also suggest that you identify those issues as to which there are differences, and that you discuss those to see if your differences can be resolved. Each of you must decide the case for yourself, and you should do so only after you've considered all the evidence and the law. Discuss the case fully with the other jurors, and listen to the views of your fellow jurors. Do not be afraid to change your opinion if the discussion persuades you that you should. But do not come to a decision simply because other jurors think it is right. Each of you must make your own conscientious decision. Do not change an honest belief about the weight and effect of the evidence. Do not change an honest belief about the weight and effect of the evidence simply to reach a verdict. Your verdict must be based solely on the evidence and on the law that I have instructed you. Nothing I have said or done is intended to suggest to you what your verdict should be. That is your decision alone. The last thing I need to do before I dismiss you to begin your deliberations is to dismiss the alternates. As you know, we have two alternates here today. I just want to explain to you what the law calls for. This is Dakota, Virginia. The court shall select by lot those jurors to be designated as additional jurors. However, in no event shall any juror be made aware of his status as a regular or additional juror until he is excused as a juror. Before final submission of the case, which I'm about to do, the court shall excuse any additional jurors in order to get to the number of 12. And what I did in this particular, because it says that I have to do it by select by lot. I actually had a styrofoam cup with everybody's number in it. There's one piece of paper for each member of the jury panel. And I pulled 2 of those numbers out. And at this point in time, I'm going to excuse juror 12 and juror 27. I want to thank you for your service. You've been most diligent. You've been worked just as hard as these folks have, but we have to get it down to 12, and it was just by lot that your numbers were picked. So with that, you are free to go with our question. Please turn that camera down. Thank you. All right, but you're free to go. If you see the clerk, oh, she's over. Okay, yeah, go. Did you leave your numbers in the jury room? Okay, did you, Pam? Okay, if you can, there she is back there by the door. All right, the remaining 12 jurors, you now, you may retire now to the jury room to begin your deliberations. Take all the time you need to reach the verdict. So with that, Sheriff back. jury, find Justin J. Sales guilty of the aggravated murder of Doris Puleio on June 25, 2019, as charged in the indictment signed by the foreperson. We, the jury, find Justin J. Sales guilty of the attempted robbery of Ann Goetz on June 25, 2019, as charged in the indictment signed by the foreperson. We, the jury, find Justin J. Sales guilty of the aggravated malicious wounding of Ann Goetz on June 25, 2019, as charged in the indictment signed by the foreperson. We, the jury, find Justin J. Sales guilty of the maliciously shooting into an occupied building on June 25, 2019, as charged in the indictment. We, the jury, find Justin J. Sales, that was signed by the foreperson as well. We, the jury, find Justin J. Sales guilty of the use of a firearm in the commission of the aggravated malicious wounding of Ann Goetz on June 25, 2019, as charged in the indictment. And again, signed by the foreperson. And we, the jury, find Justin J. Sales guilty of the use of a firearm in the commission of the murder of Doris Puleio on June 25, 2019, as charged in the indictment. Again, signed by the foreperson. Any motions?
No.
All right, ladies and gentlemen, you have to see. Ladies and gentlemen, I want to thank you for your service. You've been most diligent. I know this has been a long and probably moving episode. I can see by your faces. But I want to express my appreciation for you doing a hard job and doing it well. Madam Clerk, I believe that they are excused for the term. Is that correct? You are free to go. Thank you very much. You leave your numbers with the clerk as you leave, because we do we recycle those. And the camera will come down now, please. So you all are free to go. And if you haven't already, please make sure you leave your notebooks behind, your pads. We will destroy those. Sales, you're fine, you're guilty of aggravated murder, guilty of attempted robbery, guilty of the aggravated malicious wounding, guilty of maliciously shooting into an occupied building, guilty of the use of a firearm in commission of aggravated malicious wounding, and guilty of the use of a firearm murder in commission of murder. We'll order a pre-sentence report as well as sentencing guidelines. Do you want to pick a date at this point in time, or do you want? Let's just continue it to the opening day of the next term, because we need to get with my calendar both here as well as in Nelson. Anything further at this point in time? Anything further at this point in time? We are in recess.
Thank you. Thank you. Smaller, good bread.